The ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey guys, welcome to the Think Tank. So there's movement in the courtroom, so I thought, you know what? We'll watch and see what's going on because I honestly don't know. So let's check it out. Hope you're all doing well. It's at 11 o'clock. So I thought 11. I got messed up. Hey, Dandy, Juju, Chopper, Shauna, good to see you guys.
Sorry, I believe it's just taking a comfort break.
It's what?
He's taking a comfort break.
So let's see what's going on. Gotcha. I don't know why I thought that was our time. We're in. It's all good. I think, though, I got to make a change. I do. All righty. I have to change my thumbnail. I am so far behind, I think I'm first. Okay, it's quiet. Okay, let's see here. No, he sure didn't. Jeez, what have I done here? Well, hello, Maxie. Okay, let me do this. Geez, they've already flagged this one as we don't know if we should monetize you for this one. arseholes. I tell ya. Changed my thumbnail. So how did that work? Did you say that, Melissa, did you say that the Wells are doing a search? They were doing a search? Hmm. Yeah, they'll probably just take a look at it, Chopper, and then give it to me, because what we streamed last night, I mean, this is nothing. They're mods on a channel. I watch Matt and Noel, went to see them. I don't know that channel, though. I don't know that channel. Oh. Sorry, guys, my leg is still wounded, so I'm just like, eh. Hubby is coming home, so I have lots to do. I thought I had 2 more hours. Ferret's in the bathroom playing, so I'll have to bring him out. Put him in home.
Attorney Smith, Attorney Brooks, ready? All right, we'll bring the jurors in now. Bring them in. Please rise for the jury.
But Adam's not there? What the hell? No, I didn't have any trouble with that dandy. Noel and Matt. Noel and Matt. Yeah, I didn't have any issues, so I should be good to go. I think it's all on how you choose to watch things, like how I choose to talk about it, and I try to be careful. They have a lot of rules for me to follow, and every day it seems like there's even more. How long do you guys think this is going to go on?
All right, I'll ask the jurors to please remain standing. Everyone else, you may be seated.
Members of the jury, I'm going to swear you in now. So if you could please raise your right hands, and at the conclusion of the oath, if you would please
Really?
say,
He's
"I
on
will."
white boy lockdown?
You so solemnly swear or affirm that you will carefully consider the evidence and the law presented to you in this case, and that you will
Really?
deliver a fair and true verdict as to the charges or charges against the defendant, so help you God. Thank you. Members of the jury, you can be seated. I'm going to now read the charges to you in this matter. There's 5 charges. The first is charge ID 1937947C. This states that Adam Montgomery of Manchester, New Hampshire,
Gotcha,
of
Melissa.
Manchester in the state of New Hampshire, between approximately July 1st and July 22nd, 2019, at Manchester in the county of Hillsborough aforesaid, did commit the crime of second-degree assault. in that Adam Montgomery did knowingly cause bodily injury to HM, date of birth 6/7/2014,
Come on, give
a
her
child
freaking
under the
name.
age of 13 by striking her in the face. Said
Yeah.
acts being contrary to the form of the statute in such case made and provided and against the peace and dignity of the state.
What?
The next charge in this matter is charge ID 2027112C, and this states that Adam Montgomery of Manchester in
Is
the
a
state
piece
of
of
New
crap.
Hampshire on or about December 7th, 2019, at Manchester in the county of Hillsborough aforesaid, did commit the crime of second-degree murder, in that Adam Montgomery did recklessly cause the death of Harmony Montgomery, date of birth 6/7/2014, a person under 13 years of age, under circumstances manifesting an extreme indifference to the value of human life, by repeatedly striking Harmony Montgomery on the head with a closed fist. Said acts being contrary to the form of the statute in such case made and provided and against the peace and dignity of the state. The next charge is charge ID 2027113C, and this states that Adam Montgomery of Manchester in the state of New Hampshire between approximately December 7th, 2019 and March 4th, 2020, at Manchester in the county of Hillsborough aforesaid, did commit the crime of falsifying physical evidence, in that Adam Montgomery, believing that an official proceeding, as defined in RSA 641:1, Roman numeral 2, or an investigation was pending or about to be instituted, did purposely alter, destroy, conceal, or remove the body of Harmony Montgomery, Montgomery has been arraigned on these charges and he has pleaded not guilty, and of this he puts himself upon his country for trial, which country you are. Assistant Attorneys General Benjamin Agati and Christopher Knowles for the state have joined the issue, and you are to say by your verdict if the defendant, Adam Montgomery, is guilty of the crimes whereof he stands indicted or not guilty. Hearken to the evidence. Thank you.
Members of the jury, shortly you will hear opening statements by counsel. Before that, I'm going to give you some general instructions as to the law that applies to this case and some other matters which will give you some guidance as you consider the evidence in this case. After you have heard the evidence and you have heard closing arguments, you will hear further instructions from the court, and then you will retire to the jury deliberation room to decide your verdict. You should consider all of the instructions I give you, both now and at the end of the case as a whole, and not single out one particular instruction as stating the law. You will also have written copies of my instructions with you in the jury deliberation room. So, ladies and gentlemen, this is not a memory test. what I ask of you now is just listen carefully to the instructions that I give to you. You will have as many copies as you like in the deliberation room when it comes to decide your verdict. So you will have written copies of both the instructions that I give you now, as well as the ones that I give you at the end of the case as a whole. And every juror can have one available to them. So please just listen carefully now as I give you these instructions. The function of the court and the jury. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before deciding your verdict. You have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I'm about to give you. Regardless of any opinion you may have as to what the law ought to be, the law as I explain it to you is the law you must follow in reaching your verdict. It is up to you to decide the facts. You must decide the facts solely from the evidence in this trial. You must apply the law given to you in these instructions to the facts and in this way reach a fair and just verdict. You should decide the facts without prejudice, without fear, and without sympathy. You should decide this case based solely on the evidence presented and the law as I explain it to you. The evidence in the case. In deciding this case, you should consider only the evidence in the case. The evidence consists of testimony under oath of the witnesses, exhibits which have been admitted into evidence, facts of which I take judicial notice, and stipulations of certain facts. During the trial, the lawyers may make objections. The lawyers are supposed to object when they believe that certain evidence is not admissible. If I sustain an objection or exclude any evidence, you must not guess as to what the answer or evidence would have been. If I order that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. A judge is required to be neutral, and I am in fact neutral. If during this trial or at any point during these proceedings you believe that I have expressed or suggested an opinion as to the facts in my rulings, you should ignore that belief. It is up to you alone to decide the facts. In short, you should consider only the legally admissible evidence in deciding this case, that is, the testimony of the witnesses, the exhibits, stipulations, and facts of which I took judicial notice. We talked earlier that there will be a view in this case, and I'll give you an instruction on the view later, but the view is also evidence in the case, but you'll hear an instruction on that in a little bit. The indictments are not evidence. The fact that the defendant has been arrested and indicted is not evidence of guilt. The indictments are simply a way of giving the defendant notice of the charges. The indictments are a formal way of accusing the defendant of a crime in order to bring the defendant to trial. You must not consider the indictments as evidence of guilt. Multiple indictments, one defendant. Each of the indictments against the defendant constitutes a separate offense. You must consider each indictment separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on one of the indictments should not influence your verdict with respect to the other indictments. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge. You should base your verdict only on the evidence and the law without considering the possible punishment. The presumption of innocence. As you were instructed during the general selection process, there is a presumption of innocence that applies and continues throughout this trial until the state convinces you beyond a reasonable doubt that the defendant is guilty of each and every element of the offenses with which he has been charged. And the defendant has no obligation whatsoever to prove his innocence in this matter. And that includes the right not to testify if he so chooses. You are not allowed to draw any unfavorable, adverse, or negative inference if the defendant does not take the stand in this matter. The jury's recollection controls. You will hear the lawyers discuss the facts and the law in their opening statements and closing arguments to you. These statements and arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers have stated the law differently from the law as I explain it to you in these instructions, then you must follow these instructions and ignore the statements of the lawyers. If the lawyers state the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Direct and circumstantial evidence. There are two kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony or statement of a person about what the person saw, heard, or did. Circumstantial evidence is indirect evidence, that is, proof of a chain of facts from which you could find that another fact exists, although it has not been proved directly. For example, if you look outside and see water droplets falling from the sky, that is direct evidence that it's raining. But if you look out the window at night and the ground is dry, and again the next morning and the ground is wet, that is indirect or circumstantial evidence that it rained during the night. By circumstantial evidence, I simply mean that you may infer the ultimate fact from another fact shown. You should feel free to reach reasonable conclusions from proven facts. Conversely, you may not reach conclusions based on facts that have not been proved. In the rain example, wet ground alone may support an inference that it rained during the night. But in the absence of additional evidence, it will not necessarily support inferences about how much rain fell or for how long a period of time. You should consider both kinds of evidence. You are permitted to give equal weight to both, but it is for you to decide how much weight to give any evidence, whether it be direct or circumstantial. However, to be sufficient to establish guilt beyond a reasonable doubt, circumstantial evidence must exclude all other rational conclusions. This means that if from the circumstantial evidence it is rational to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the rational conclusion consistent with innocence. In determining whether all rational conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all of the other evidence, which includes all other circumstantial evidence and direct evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. If there is a conflict between two or more witnesses who offer direct evidence concerning certain facts, you should resolve the conflict. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in direct evidence. In this situation, you, the jury, should resolve the conflict and must decide whether, based upon all of the evidence, the state has proved the defendant's guilt beyond a reasonable doubt. You should consider all of the direct and circumstantial evidence in the case, as well as any reasonable inferences you draw therefrom, in deciding whether the state has proved all of the elements of the crime beyond a reasonable doubt. The credibility of witnesses. In deciding this case, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. Use your common sense and judgment. Consider factors you use in deciding important issues in your everyday lives. For example, you may consider the following: the witness's attitude, behavior, and appearance on the stand, and the way the witness testifies. the witness's age, intelligence, and experience, the witness's opportunity and ability to see or hear the things about which the witness testifies, the accuracy of the witness's memory, any motive of the witness not to tell the truth, any interest that a witness has in the outcome of the case, any bias of the witness or friendship or animosity the witness may have for or against any of the other people in the case, the consistency or inconsistency of the witness's testimony, whether or not what the witness says appears reasonable or unreasonable, whether what the witness says is consistent or inconsistent with the testimony of other witnesses or with statements the witness made at another time. In deciding which witness to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witnesses. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted. Nor are you required to accept testimony as true because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a larger number. These principles apply to all witnesses, whether they are ordinary citizens, police officers, experts, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. The weight to be given to the evidence should be determined by the quality of the evidence, not the quantity. It is not the number of witnesses or the quantity of the evidence, but the quality of the evidence that is important. The judge decides what is admissible. Testimony, writing, objects, and other things presented during the trial are evidence only if the judge accepts them as evidence. Throughout the trial, I may rule on whether certain evidence was admissible or not admissible. These are legal decisions which do not concern you because only the judge is permitted to decide legal questions. I may make three types of legal decisions with regard to the evidence. First, I may stop some information from being presented at all. You are not to imagine what that information might have been had I allowed it to be presented. Second, I may rule that some information was not admissible after it was presented to you. You are to ignore this information and not use it as evidence. Finally, I may allow some information to be entered as evidence after hearing objections by one of the lawyers. You are not to give such evidence any special importance as a result of my ruling. It is not my duty, and I do not try to determine whether the evidence is important when I make my rulings. The burden of proof and reasonable doubt. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss with you how convinced one way or the other you must be, and this is referred to as the burden of proof. Under our constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. As I told you earlier, the defendant enters the courtroom as an innocent person, and you must consider him to be an innocent person until the state convinces you beyond a reasonable doubt that he is guilty of every element of the alleged offense. If after all of the evidence and arguments, you have a reasonable doubt as to the defendant having committed any one or more elements of the offense, then you must find him not guilty. Now, finally, ladies and gentlemen, a reasonable doubt is what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based upon reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all of the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proven any one or more elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proven all of the elements of the charged offense beyond a reasonable doubt, you should find the defendant guilty. With respect to the final instructions regarding the offenses, I will wait until the end of the trial and after closing arguments and discuss it with you at that time. So as I said, I will give you another set of instructions after closing arguments at the end of this case. You will have all of these instructions with you in the deliberation room when it comes time to decide your verdict. As I said to you earlier, there's a form of this instruction that I'm about to give you. We call it the communication instruction that I'll give you. I've given you some of it before, and I'll continue to give it throughout the trial. Please listen very carefully. Do not discuss the case at all, not with the other members of the jury or with anyone else, until jury deliberations start at the end of the trial after all of the evidence and final arguments have been presented. Please keep an open mind until you have heard all of the evidence in the case. During the course of trial, please take care to avoid any contact with any persons involved in the case, the lawyers, the witnesses, and the parties. So I remind you, ladies and gentlemen, as you come in and out of the courthouse, you may see the lawyers or other people involved in the case. They have been instructed that they are not to communicate with you, so they are not being rude if they don't acknowledge your presence or smile at you or say hello as you may pass them in the hallways. But you must, they are required to avoid any contact with you, and you are required to avoid any contact with them. So no contact with anyone involved in the case, please. Also, please be sure to avoid any television, radio, online, or newspaper coverage of this case. I anticipate that there will be media coverage of this case. As I indicated earlier, you know that there are cameras in the courtroom. They have been instructed that they are not to take pictures of the jurors in the case, but I expect that there will be media coverage. You are instructed that you must not read any articles or view any media coverage on television, online, or elsewhere. So avoid your local papers, have somebody pull the international section if you want, but don't watch any media coverage of the case, okay? You are instructed to turn off any notification or banners that come through your smartphone, computers, smartwatches, or other devices, okay? Finally, do not conduct any research or investigation of your own. You must render your verdict based solely on the evidence submitted at trial. So don't look up the law. That will be given to you in the court's instructions. Don't drive by any locations. Don't look up any names. Don't look anybody up on social media. It is critically important that your verdict in this case is based exclusively on the evidence that's presented at trial. Our trial day will generally go from 9 a.m. to 4 p.m. We will also generally take a mid-morning and mid-afternoon break. I try to look at sort of natural break points in the case to determine when those breaks happen. But generally we'll have a mid-afternoon, mid-morning break, and we'll also have a lunch break. The court has asked you to put your cell phones in a box in the jury deliberation room. Please make sure they are silenced or turned off altogether. As I said to you, you will be permitted to check your phones when you are on break. However, you are not to look at any news reporting or media coverage of this case, as I have already told you. Additionally, you are not permitted to take notes of any kind, not on paper nor on your phones. The reason for this is that it is important that your recollection of the evidence is what controls. Sometimes if notes are taken, they can be given undue weight, and it's important that when it comes time to deliberate, you are using your individual and collective memories about the evidence, and one note or one written recollection doesn't control. You should also be aware that there will be no transcript available to you when it comes time to deliberate. So although we have our excellent court monitors here, And there's an audio recording that is not available to the jurors, and there will be no transcript. So your individual and collective recollection is what will control as you go into the deliberations. Therefore, please listen carefully to the evidence as it is presented. If during the course of this trial you have any questions or problems, you become thirsty or need anything else, just get the court officer's attention, either of our court officers or my attention, so that we can assist you. If at any time during the trial you cannot hear, please raise your hand so that I can ask the witness or the lawyers to speak up. That goes as well for any monitors. If you cannot see, please do let us know. It is important that you are viewing and listening to all of the evidence as it's presented. So, ladies and gentlemen, it is now 20 of. I had indicated to you earlier that I thought we would go right into opening statements, but based on what I anticipate the length of the opening statements will be, I think that would hold your lunch off for quite a long time. So, after speaking with the lawyers, I think what we're going to do is we'll take an early lunch break. So we're going to break now. Please come back at in 1 hour, so 20 to 1. And then we'll move directly into opening statements. So don't talk about the case, not with each other, not with anybody else. Don't look up any media. Don't do any independent research. And I will see you in an hour after lunch. Thank you so much, ladies and gentlemen. All rise for the jurors.
Okay, then I'm going to set up another stream, and for an hour from now. So I will see you in an hour. Okay, friends, I'll see you there. Bye for now. Thanks for being here. I didn't expect this. Well, let's just make sure we're done.
12:30, or what would you like to do?
Just thinking, Your Honor, with regards to the arrangements for the bus. Just trying to figure out what the time is and what we can do with them to, because we're shifting.
He must not be in there, because why would he be up talking to the lawyer?
Sure.
Interesting. Okay, guys. I will see you guys in the next one. Bye.